Thank you. You may be seated. Good morning. This is the time set for oral argument in U.S. Bank versus Adrian. Our case number 1 CACV 200488. Each side will have 20 minutes to present their argument. Appellant, if you wish to reserve time for rebuttal, you'll need to watch the clock and preserve some time for that. These proceedings are being video recorded. We would appreciate, and sometimes you can also listen to the audio, we would appreciate it when you approach the podium for the first time if you give us your name and the party that you're representing. We have read the briefs, we've conferenced this matter. We think we're familiar with the facts and the issues, and we're looking forward to hearing from you. And with that, counsel, you may begin.
Thank you, Your Honors. Brian Cosper appearing on behalf of the appellant, in this case, U.S. Bank. This case is about equitable subrogation, as the Court's well aware. My client's loan paid off a personal debt that Ms. Adrian owed to Custom Lot Finance that led to a release of a lien from her property. That was a consensual lien that she willingly granted to Custom Lot when she pledged her property as collateral for repayment of that loan. She gave nothing in exchange for repayment of that debt. A significant financial windfall she received as a result of my client's loan proceeds paying off her loan. Equitable subrogation is designed exactly for a circumstance like the one presented in this case, to avoid one party retaining a benefit to the detriment of another party. The trial court's ruling here on summary judgment against my client and in favor of Ms. Adrian should be reversed, and this court should award equitable subrogation. I don't think it warrants a significant recap of the facts. I think the most relevant facts, of course, are that Ms. Adrian was previously the sole owner of this property. She borrowed $550,000 jointly with her brother-in-law and secured that loan with a first position deed of trust against her property. Sometime later, she conveyed a 1/2 interest in the property to her brother-in-law, who then 8 or so months down the road applied for a loan with Quicken Bank, the predecessor to my client. That loan was for $313,000, and the purpose of it was to repay the portion of the prior loan allocated to Miss Adrian's property. Quicken funded the loan with the belief and understanding that it would receive a first position lien against the entire property as a whole, and would not have funded the loan but for that belief.
Counsel, that belief proved to be wrong.
That belief did prove to be wrong, absolutely. Mr. Underwood was only a 50% owner at the time he applied for it. That's absolutely true.
And did the recorded document show?
The public record did. That's correct, Your Honor. The deed was duly recorded. For purposes of equitable subrogation, constructive notice that might be assumed based on a recorded document doesn't really matter, because ultimately the purpose of equitable subrogation, again, as I mentioned at the outset, is to prevent unjust enrichment. And oftentimes, a subsequent lender doesn't just have constructive notice, it has actual notice of intervening interests.
And your position is, and again, this is a hypothetical in this case, but your position is that actual notice would not defeat an equitable claim?
Hypothetically speaking, I suppose it's possible that it could. I don't think that it would in this case. And there isn't evidence that there was actual notice, and I think that was one of the underlying problems with the trial court's ruling on summary judgment, is the trial court reached the conclusion that the bank had information that made it aware of Miss Adrian's 1/2 interest in the property. The only document in the record before the trial court where her interest was in fact disclosed was a 1-page document from Title Now, which was in the title company's file. Miss Adrian didn't...
Counsel, was Title Now working for Quicken?
I don't believe so. And there wasn't, actually, there's no evidence of what Title Now was. The title company that handled this was Title Source. This 1-page document, there's no foundation for it, no explanation of its existence or its purpose. It was prepared by, apparently, a third-party company On its face, it notes that it's not to be relied upon as a representation of the status of title. And again, I think as to the actual notice issue, there's no evidence that that document was seen by or relied upon by Quicken when it made its decision to fund the loan. And I think to the contrary, in fact, the title commitment that the title company did in fact prepare, which offered to insure Quicken's loan, did not disclose that Miss Adrian was a one-half owner of the property.
Is there any evidence that Ms. Adrian received any of the proceeds of the loan?
There was no evidence in the trial court proceeding about how the proceeds were used. However, what was in the record is that the loan proceeds from Quicken's loan were directly applied to pay off a personal obligation that she had incurred to Custom Lot, which was the prior loan in the amount of $500.
Did she receive a personal benefit from that initial lot, or was she a guarantor?
Well, she's
Does
a
that matter?
I don't think it matters. I think whether or not she received a benefit from it, she was obligated to repay it. I think that's what matters. It's a personal debt that she freely and willingly incurred, jointly with her brother-in-law, of course, but it was something she was personally responsible for. And more importantly, I think to the facts of this case, she was more than happy to give up a lien against her property to secure repayment of that loan. She freely did that. That was a choice she made. The fact that she may or may not have actually handled the cash from that loan, I don't think matters. I think it matters that she was legally obligated to repay it.
Even in the context of equitable subrogation, if all of the proceeds went to Mr. Underwood, she's a passive guarantor, there's a new loan that comes in that she's not aware of, just in the world of equity, when she doesn't appear to have benefited at all, we can't consider that. You're saying it's just she had that obligation under the original deed of trust.
I think that's right. I think the question is, when you compare, equitable subrogation is designed to prevent a windfall. There's no question that she was relieved of a significant personal obligation and her property interest released from a lien that she had consented to. When you compare, what Quicken did, of course, was loan on the assumption, mistaken as it turns out, that it would receive a first position lien in the same position that was assumed by the Custom Lot deed of trust. That loan never would have happened but for the mistaken belief that Quicken had.
What do we make of the fact that there was additional security on the first loan?
I think it's not relevant for purposes of equitable subrogation, and I think the White's or Wheat's case talks about that. When there's a blanket, a big loan and portions of it are paid and releases as to specific parcels are granted from a deed of trust, that's very much akin to what we have here. The Custom Lot loan, yes, it was secured by two different pieces of real property, but there were two separate deeds of trust, and it was obvious that the prior lender believed and agreed to partial releases under that Custom Lot loan. And what we have here is a complete repayment of the portion of that loan allocated to Miss Adrian's property and a release of the deed of trust.
Let's say even if she were aware of this restructuring, didn't she lose the benefit of some additional security that could have paid off the Custom Lot deed of trust?
I don't think so, and I think the better way to think about it in this case is she was, the amount of the debt that needed to be repaid for her property to be free and clear was significantly less as a result of Quicken's refinancing. The Quicken loan and deed of trust required only a $300,000 repayment, whereas the Custom Lot loan was $550,000 in its original amount. Cross-collateralized, meaning if there was ever a default in repayment of that full amount, that lender could take both properties. That's different now. She's in a much better position. The risk, one of the reasons why equitable subrogation sometimes doesn't apply is if there's material prejudice suffered by the party against whom the doctrine applies, Miss Adrian in this case. And what the cases tell us is that when you're considering prejudice, you look at the risk that the party voluntarily assumed and compare it with the risk that would be imposed with equitable subrogation. And that's sort of what we just talked about. The risk that Miss Adrian voluntarily assumed was that she would lose her property if she failed, and Mr. Underwood failed to repay the $550,000 loan to Custom Lot. The risk that she faces with equitable subrogation is less. It's $300,000. Both of them have a first position lien that theoretically could be foreclosed, but she faces a significantly less great risk financially speaking because the debt is smaller, significantly smaller.
But there's no argument that Ms. Adrian had consented to the reduction of the cross-collateralization, is there?
She didn't know about the Quicken loan. Is that what you meant, Your Honor?
But so you would agree with me then that Ms. Adrian had no part, no knowledge, and no agreement to the elimination of a cross-collateralization?
I would agree with that. There was no evidence that she was aware of this loan at all. But I don't think that really matters in the equitable subrogation context. And there are cases from other jurisdictions that we cited in our reply brief, that are directly on point on that issue.
Some of those cases, what's the best one? The ones, when I looked at one, for example, the Maine case, there are people who are on the mortgage, they're making payments. It seemed different than being a passive guarantor, and that they clearly, if the proceeds go into improving the property, that seems like a much better case for equitable subrogation. Which one of the cases or ones do you think are most directly on point or most helpful to your position?
Well, I think they're all directly on point, and the Maine case is, I think, a good example. The senior lien in that case was consented to by two groups of co-tenants. It was a mom and a dad and a son and I guess, his wife. Both parties, both sets of co-tenants had initially taken out a mortgage loan secured by a deed, or I guess a mortgage against their entire property interest. The son and the daughter-in-law went and got a different loan that paid off that first position lien. That's exactly what we have here. And they did so without the other co-tenants' involvement at all. The loan exceeded the amount required for payoff, so there's a separate issue, which is that the lender was entitled to an equitable lien for the difference between the payoff amount and the mortgage amount, because the property was actually improved with those funds. But if you put that issue aside, because we don't have it here, the point is the amount that was paid to release the senior lien encumbered their property under equitable subrogation because they directly benefited from it. It paid and discharged a personal obligation that they freely incurred, just as Miss Adrian did so in this case when she signed.
So it doesn't, the fact that it's a guarantor in your view isn't a difference in the Maine case where they were receiving the proceeds, making payments on the loan. You're saying it's just Ms. Adrian assumed the obligation and was in the same position essentially as the parties in Maine.
Absolutely, and I think that the way that I would look at it is look at the lender who loaned the money to Miss Adrian and Mr. Underwood. Same perspective for that lender as the lender who loaned the money to the mom and dad and the son and daughter-in-law in the Maine case. It doesn't matter what the purpose was, whether they're passive guarantors, as the court has framed Miss Adrian, or more active guarantors. They're all equally responsible for repayment of that debt, and they've all voluntarily pledged their property as collateral for it.
And your position is that the use of the funds in the Maine case to improve the property itself, unlike this case, that difference matters not in the analysis?
Well, I think that's right, Your Honor, because if memory serves, in that case, the court held equitable subrogation would apply up to the amount of the debt repaid, and the additional amount borrowed by the son and daughter-in-law without the mom and dad's knowledge would still be imposed as an equitable lien against mom and dad's interest in the property, because the lender because they benefited from it, and the lender should as well. We don't have a situation here where there's excess money that my client is claiming should be a lien.
No, we don't, but we also don't have a situation where proceeds were used to improve the property that secured the loan. Right?
No, we don't have that circumstance. That's absolutely right. And the other co-tenant cases which we cited in the reply brief don't have that scenario either, if memory serves. I think the case out of, let me pull up my notes, either Iowa or Indiana.
What's the most recent one? It seems like Iowa's from 1928. Is there something more recent, or but you're just saying these are good law, stand for the proposition that's presented?
Well, the most recent case is the Maine case, which I think was from the 95, perhaps. The Iowa case from 1938, and the Indiana case may have been before that, I don't recall, or maybe 1940, excuse me. I think it's good law. It's consistent with the restatement's expansive view of equitable subrogation, which has been adopted here in Arizona. I think the default rule under the restatement is that when one person pays the debt of another for the purpose of protecting the interest they intend to acquire in the property, equitable subrogation should apply in most cases, and only when there's prejudice shown by the person affected by equitable subrogation is there a question of whether it does in fact apply in a particular case.
What would be your argument if, let's say, the new loan were at double the interest rate, making it more likely that it would be something that might be defaulted? Would you still take the same position, equitable subrogation applies?
Yes, I think materially different terms sometimes can result in prejudice. That's a fact question, which wasn't resolved here. I think the facts would show that the interest rate is more favorable under the bank's loan. But having said that, even if that wasn't the case, the Arizona case law, I think Lamb talks about this and some others after it, that the trial court it's an equitable remedy. So the trial court can fashion a remedy that results in no prejudice to the person sitting in Miss Adrian's shoes. With respect to interest, the way that works is that the debt balance to which my client would be subrogated is calculated with the original loan's interest rate, so that she's in exactly the same position that she would have been in had the original loan not been paid. And that's what equitable subrogation aims to accomplish. It puts the subsequent lender in exactly the same position as the senior lender had paid off.
What's your view of the restatement position that if you bestow an unsolicited benefit on someone, you're not entitled to recover absent some sort of misconduct by the person who received the benefit?
Well, I think that gets to the idea of a volunteer, right? I mean, that's not what the bank did in this case, or Quicken did in this case. It never would have made the loan if it had been aware of Miss Adrian's interest. That's the problem here, is there was a mistake. It was not appreciated and not known by the bank at the time the loan was funded that she had this outstanding interest in the property. The bank didn't make this loan gratuitously. It did so based on its mistaken, as it turns out, belief that it would in fact receive an encumbrance equal to the position held by Custom Lot's deed of trust as a first position lien against the entire property. But
the bank essentially wants to make Ms. Adrian a guarantor on a note that she knows nothing about. But you're saying it doesn't matter because she was essentially obligated, and so this doesn't change her obligation?
I don't think she was essentially obligated. She was obligated. She took this loan out with her brother-in-law, and she pledged her property as collateral for repayment of that loan. What my client seeks to do, and what equitable subrogation allows it to do, is stand in the shoes of the lender that she agreed to pledge her property as collateral for. There's one other point I want to mention, and I'll sit down and reserve the rest of my time for rebuttal. To the extent that that Ms. Adrian does in fact prevail, she made a claim for attorney's fees under 12-340-101. The case law is pretty clear that a claim for equitable subrogation is in fact equitable in nature, does not arise out of contract. So I just wanted to address that briefly here before I sit down as well. And unless the court...
It doesn't arise out of the contract between Underwood. I mean, they're saying it's as a result of this loan, which seems to be a contract. But you're saying in the context of unjust enrichment that doesn't apply?
That's correct, Your Honor. And it's I think the U.S. Bank v. Chase Bank case here and Brymet 2 LLC v. Destiny Homes both directly address this issue and say that an equitable subrogation claim does not arise out of contract, even though there are contracts that are a necessary predicate to those claims. With that, I'll save the 2.5 minutes I have left for rebuttal unless the court has questions. Thanks.
Good morning, Your Honors. I'm Thomas Murphy here on behalf of Dawn Eva Adrian, who's behind me here in the courtroom. Brian and I were talking here before we started how this is the first time either one of us have been in court in over a year. Well, when I pull in the parking lot here, I get out of my car, I'm like, where's my jacket? So I guess I'm not quite totally up to speed yet, so please excuse not being fully dressed. But to get to the point here, Your Honor, I think Mr. Cosper's points would be much better taken if Quicken or the bank had assumed the entire custom lot loan and not just a portion of it. And because if you look at the cases such as the main case and some of the other cases that are cited in the various briefs, including the reply brief, there's this sort of sense of like no harm, no foul. Like in the main case, they were saying, well, all right, we had these two couples that were on this loan, and one of them refinanced and the other one didn't know about it. But at the end of the day, the couple that didn't know about it, well, it's the same, more or less the same obligation, it's just a different lender. It's like rather than owing the money to lender A, it's now lender B. Otherwise, what has really changed? Should you really be now off the hook just because you didn't know about that new loan? So that's why I keep coming back over and over again about this is not just simply Quicken, or the bank now stepping into the shoes of custom loan. I mean, a custom lot. It's an entirely different loan. And so I agree entirely with the comments, Your Honor, you made earlier about, she's lost a source of collateral. The bank is trying to say, oh, well, she only owes now $300,000 rather than $550,000. Yeah, but she also lost a source of collateral.
What did happen with the other property? What there was a loan on the property. I don't recall from the record what.
No, I don't know. That was all way before I was involved in the case. So no, we don't have a record of what exactly happened on that. But the point is.
But if that property were still available to pay the loan, then she clearly hasn't been prejudiced. Isn't that accurate?
Correct, but obviously that's not the approach they're taking. They're going after her property and not the other property.
But does she have an obligation to come in and say, no, this is, I now have, there's less security for this loan because there's no longer this other property that's available? What if the other property is now free and clear and that could be used to pay that initial loan that?
Again, that would be a valid argument, Judge, if the whole loan had been refinanced. Instead, they're just saying, no, we're only dealing, the only collateral for this loan is the Peoria home that Miss Adrian had. So, no, I don't think she probably could.
So the Quicken loan didn't pay off in any way the other collateral?
No, and where that money went, we don't know, Judge. And likewise, we don't know, one of the mysteries in this case is, where did the $300,000 come from? I mean, obviously, Eva never agreed to that. And, if Miss Adrian had been involved in this, who's to say the loan wouldn't have been for $250,000 or $200,000, rather than $300,000? It's, from our standpoint, it's a totally arbitrary amount. Where did they come up with this $300,000? I understand that's what custom loans said. Oh, we'll go ahead, we'll release this collateral if you give us the $300,000, but what does that, what was that tied to? We don't know.
But why does it matter what it's tied to if it relieved your client of the obligation to pay on the $300,000 loan?
Well, what I'm just saying is, how did they arrive at $300,000? How do we know
wasn't the amount of the deed of trust for $300,000? Wasn't the amount that was that Ms. Adrian guaranteed? Wasn't that $300,000? So didn't she receive that benefit when that was paid off? Am I missing something there?
No, the $300,000 has never been paid off. That's what we're arguing over right now.
But she was on the hook under the original deed for $300,000. So
actually $550,000.
Okay, but the bank is saying she's no longer on the hook. She's just still on the hook, just the way she was before the Quicken loans.
Right, but the problem is there's only one source of collateral, not two. And that makes a big difference. That's what I'm saying. If the entire loan had been refinanced, a custom lot loan had been refinanced, I think their argument for equitable subrogation would be in a much stronger position. But here, that's why I keep saying that they did this on their own, and it's not because if you look at some of the cases you just mentioned earlier, like the Maine case and that Iowa case and so on, the whole idea is it's more or less the same amount of loan, it's just a different lender. And that's not the case here. I mean, the way I think of it is Eva Adrian in the same position after this as before the loan? So in other words, before the Quicken loan, is her position the same as it was after? And that's clearly not the case. I mean, we're talking a totally different situation. And that's why when I was reading those cases that were cited in the reply brief, I was like, this is exactly what I'm talking about. I mean, this is not the same loan. All those cases basically involve a situation. One was a probate where husband and wife go in a loan, husband dies, and now the wife wants to refinance. And then apparently the kids come in saying, oh, hey, we're, dad's beneficiaries, we didn't agree to this. But they were saying, you know what, you were all, both your parents were on this loan to begin with. All we're doing is just refinancing this existing obligation, which you at one point were liable on anyway. But it didn't, from what I could tell, it didn't materially change the obligation. So that's why I keep coming back to this thing. It's sort of like same obligation, just a different lender. And that's not what we have here. It's a totally different amount. And that's why the cases also emphasize that, gee, the person who's obligated on this loan, their position never really changed. And I think you have to say as a matter of law that Ms. Adrian's position's changed. She lost a source of collateral. So whether they can try to make the argument, well, she's on the hook for less than she otherwise would be, well, but the bottom line is she also has less collateral. And I don't think it's in this court's position to decide, well, is it better or worse? The court just talks about in terms of, has there been a change in position?
Is that a fact question? What if that other property is more valuable? I'm assuming it's not, since they're not able to collect against Mr. Underwood. But is that a fact question that should be resolved?
I don't think so. I think as a matter of law, when you lose, half the collateral, that's a significant change. And that's why several times in their briefs, the bank has taken the position that there was no change. I'm like, how can you say that? She lost, we don't know how much the other commercial property was worth, but it's a commercial building. It had to be worth a substantial amount, and that is now gone. And I don't see how you can possibly say that that did not result in a change in her position. I mean, as a matter of law, when you lose, collateral like that, yes, there's a change. And all I'm saying.
Let's say that the Quicken Loan hadn't gone through, and Mr. Underwood just stops making payments. I mean, she's on the hook. So why isn't that what the bank is suggesting? That's just the same thing. You stop making payments, she's on the hook.
She's on but again, there'd also be that second source of collateral there that, we don't know what it's worth other than the fact that apparently it wasn't worth $550,000. That's why, Miss Adrian had to get involved. But I'm just saying, whenever you lose a significant portion of collateral, your position has changed. And so that's why I think the cases that the bank keeps relying on, Maine, Iowa, and so on, those are readily distinguishable from what we have before us here. Again,
let me ask you, assuming I accept your position that those are factually distinguished, because they stand for the proposition that the guarantors or the parties that put their property up to secure a loan really didn't change. It was just sort of the lender, it's like selling the paper as opposed to renegotiating. So those cases are distinguishable. But to follow up on Judge Catani's question, why isn't this sort of change in circumstance and all the other things we're hearing about today, why isn't that a factual issue that needs to be resolved at trial as opposed to an issue that can be resolved in summary judgment?
Because I think just the fact that there's no dispute that the collateral was lost, right? That's not a matter of dispute. And what I'm saying is that's as far as you need to go. We now have a change in circumstance, and the various cases that we've been discussing here all assume that there is no change. It's kind of like no harm, no foul.
Again, counsel, I'm accepting that whole cloth. So all those cases go away. The Maine case, the Iowa case, they go away. So accepting all that, why is this summary judgment as opposed to an issue to be resolved at trial?
Again, because I think just because it's not disputed that the collateral, half the collateral disappeared. There's no factual dispute as to that. And that's what I'm saying. That's all we need to know here. We don't need to get into this thing about is Miss Adrian better off on a $550,000 note with two sources of collateral or a $300,000 note with one source of collateral? What I'm saying is all you need to know is those are different.
But what if there was evidence that a week before the Quicken Loans was issued that the property was completely destroyed that was being used as collateral for the $550,000. At that point, the only real recourse, let's say it was a natural disaster, wasn't insurance, whatever. The only recourse for the bank is the is your client's property. So if that had happened and Quicken Loans comes in, how has she been?
Well, I guess Custom Lot would not have agreed to that. They would not, if they now only have, in effect, one piece of collateral, which is Miss Adrian's property, Custom Lot would not have agreed to let that go. I mean, is what I would think.
Do we know that? Is that in the record or not,
What?
what you just said?
That if the other property had been destroyed?
Correct.
It just never came up. There's nothing in the record on that, and I'm not aware of anything happening to the other piece of property. A couple of other points is, one thing that caught my eye in some of these other cases we've been talking about, and I realize they're outside of our jurisdiction and all that, is they did discuss the standard of review. And I know the bank has sort of poked fun at me on that, but I was surprised that when we're talking about a court's decision to exercise equitable jurisdiction, which I think has been kind of overlooked in this case, everyone just assumes, oh yes, we're entitled to talk about equitable subrogation, but all along I've been saying, well, wait a second, this is an equitable remedy, and so that's obviously a fact-intensive thing. The judge clearly decided that because of what went on, he didn't want to exercise any kind of equitable jurisdiction in this case. So I'm surprised that the standard of review, at least in some of these cases, seems to be just a de novo review, rather than in some of these other cases. I think the main case was one of them where it specifically said it was using more of like a clearly erroneous standard.
But that back to my question, doesn't that turn on how the case comes to us? I mean, if this case came to us after trial, there's no question it would be an abuse of discretion standard of review. But it came to us under Rule 56, and I know of no Arizona case law saying that's anything other than de novo review.
Right, but it just in those same cases also talk about, but it's the court's discretion, and so it's just I'm just a little bothered by that. I'm not asking the court to make any new law on this, but that was just something that caught my eye. Is that on some of these other cases they clearly were using a clearly erroneous standard. They didn't use quite that term, but that's the standard that they were using. So I think that needs to come into play. I'm also bothered by the fact that all the things that the banks didn't do, the bank is taking a position that doesn't matter. I mean, the fact that, this is basically a breach of contract against Donnie Underwood. And I'm bothered by the fact that the bank can say, oh, we don't need to go after him. We can bring in this third party who had nothing to do with this Quicken loan and go after her and not go after Donnie. And that was clearly before the court. There's no question.
But that's a contract action. They're just saying there's an unjust enrichment because she clearly received a benefit.
Right, but what I'm saying is, if I was the one writing the law here today, I'd be saying, if you're going to ask me to exercise equitable jurisdiction, you better have exercised all your remedies at law before you come to me asking for an equitable remedy. And they never went after Donnie,
Counsel,
Donnie Underwood.
What do you make then of the counter to that, which is that an unclean hands argument has to invoke willful misconduct? So it's, in other words, the counsel's argument in their briefing is negligence is not enough. So if they say, hey, mea culpa, we screwed up, but we're going to hold Ms. Adrian accountable for that screw up, and we're allowed to do that.
Yeah, I don't think the case law is totally consistent on that, because in the next breath they start talking about, oh yeah, judge's discretion and all that sort of thing, in invoking its equitable powers. And that's what I'm saying. That's what kind of bothers me about this, is that why aren't we looking at the fact that the bank could have gone after Donnie? They never did. They can't now. Too much time has gone by. But they can go after the one party who everybody agrees had nothing to do with this, with this loan. That just doesn't strike me as right.
You're not disagreeing with the main case if absent this problem that it's a different restructuring. But the main case, they could have made that same argument. The bank should have gone after someone else or done something. The bank should have known something. That doesn't. I'm not sure that gets us anywhere in terms of the benefit and equitable subrogation.
It did kind of come up in the Source Corp case, where they made the argument that, gee, you could go after the title company that that messed up, but they were saying, well, wait a second, let's deal with the two parties that are here right now. We don't need to bring in the third party, which is what they're trying to do here.
Let me ask you, was there an attempt to join any of these other parties on behalf of your client in this case?
Join which parties? Like Donnie and?
Yes.
What they did is they named Donnie, when I say Donnie, that's William Donald Underwood, okay?
Who's deceased.
Right.
And
They,
isn't there a default against his estate that was entered?
no, that was entered against Donnie's widow, who has never been represented. She defaulted and all that, but I don't think the bank should have been allowed to do that, because what they...
Well, and that's not in front of us, but your point is basically you don't cut to equity until you determine that your legal remedies are inadequate. And what we're pressing you on is what legal remedies does the bank have that you believe are adequate?
Donnie, to go after Donnie's estate.
And that, again, was my question. There was a default against his widow, right?
Yes.
Right. And,
Not against Donnie, not against Donnie's estate.
and you didn't seek to join Donnie in this case either, correct? Or his estate?
Not his, I mean, that's up to the bank. They're the ones that are, claiming that he breached the agreement and, misrepresented and all that sort of
I
thing.
understand that, but I thought I heard you say that we shouldn't be at equity yet because we haven't exhausted law. And that would, if you're making that argument, I think, fairly impose upon you a burden to do something.
And the same burden is on the bank, Your Honor, too. I mean, shouldn't they before...
But it's a defense that you're raising. That's my...
Well, the defense is just that when we get back to this whole, sort of, squishy notion of equity and when does a court get involved and so on, I mean, I can just tell you, if I was behind the bench, I would have expected the bank to get some sort of judgment against Donnie's estate. To not even try to do that, that bothers me. And I don't think they should be allowed to go after somebody else when, whatever you want to call it, the tort fee.
What if it's clear that there's just no assets there? Why doesn't it just make sense for the bank to go, well, we had security? That's the point of, again, if there hadn't been the new loan and Underwood's just insolvent, there's nothing to be gained there. Why is there an obligation for them to do something that will just cost money and not result in anything?
And that would be the whole point of the probate, is to figure out what else is out there. Now, if in fact he was insolvent, then yes, that makes their argument more stronger as far as some sort of subrogation. My whole point is that was never done. I mean, we don't know if he has other assets out there that could be used to satisfy him. And now, because they never asserted a claim against his estate, they can't go after it. And, Donnie's estate could have $1 million. They can't do anything about that now, and they never even tried to go after that. And so that's what I'm saying from an equitable standpoint. That really sticks in my craw that they can come after Eva in essence say, yeah, Donnie, we're not going to bother with you. But, Eva, the one person everyone agrees was not at fault, had nothing to do with this, they get to go after her. That just doesn't strike me as fair, Your Honor, or
equitable. Did you address counsel's argument regarding fees? What's your position on why if your client were to prevail, why would she be entitled to fees?
I think the position is clear that they were not entitled to go after her, that there is no equitable subrogation here because it's an entirely new loan. So
What's your basis for fees, though? You're saying it arises under contract?
Well, yeah. I mean, it's kind of like what you were saying earlier, Judge. I mean, yes, I realize the notion of what exactly a contract under 340-101 is, pretty generous. And so I would say that, yes, that it does apply because the loan that they're claiming Ava was a part of, I mean, that's a contract.
What's your best case for that, or do you have one on that?
I don't have one right in front of me, Judge. And with that, it looks like I'm out of time.
Thank you, Your Honors. I'd like to address just 2 points very quickly. The first is that I think the way the record developed in front of the trial court, there were 2 options. Either to grant my client's motion for summary judgment, finding that because there was no question that it paid a debt that Ms. Adrian was obligated to repay and a lien was removed from her property as a result, as a matter of law, that entitles my client to equitable subrogation. In the alternative, as was discussed when Mr. Murphy was arguing, there might be questions of fact that require weighing of the equities. For example, the argument that removing the one source of collateral causes her to be prejudiced. I disagree. I think that the lessening of a debt burden is the benefit more so than losing the collateral as a detriment. But at a minimum, if that's something that the court finds value in, that's a question of fact that the trial court was required to resolve. This notion that there's a change in her position, again, I think that can either be resolved in my client's favor on summary judgment, and the way that result occurs is an analysis of the risk that she faces. Under the custom lot loan and deed of trust, she faced the possibility of a foreclosure under a first position lien. She faces that same risk if equitable subrogation is applied. So summary judgment could be granted in my client's favor, but again, it can't be granted against my client because there's questions about whether she's in a worse position or a better position to the extent that the court gives merit to this notion that collateral was removed.
But collateral was removed, so how can you possibly be entitled to summary judgment if you're saying that you're just saying that just can never possibly change the analysis when there was another piece of property that was also securing this loan that's now not securing this new loan?
Well, I think we're more in line with the White's case at this point. There's separate deeds of trust. Obviously, custom lot assigned a particular value to each property, presumably $250,000 to the other property, and $300,000 to hers. They were under separate deeds of trust. What matters is that her property was subject to a $300,000 lien, and she agreed to that. That lien was repaid and released as a result of Quicken's loan, my client's predecessor's loan. It should be, entitled to a subrogation up to that same amount. That's what that's the purpose of it. And then finally, the last point, this discussion about legal remedies, the case law is clear. The question is whether a party asserting equitable relief has legal recourse against the defendant that was named in that lawsuit. That's the Lois L case. It says it directly. The fact that there may or may not be legal recourse against third parties is irrelevant for purposes of evaluating the equitable relief that's sought in this particular case. And with that, I'll go ahead and sit down. Thank you, Your Honors.
Thank you both for your argument. We will take this matter under advisement and issue a decision in due course. And with that, we're adjourned.